Well, first of all, it's the way we all should behave in the first place. Like our mothers told us, be nice to people, the golden rule, all those things.
That's pointing to me right now.
Correct. Well, we're on the record.
Right. I want these cameras out of my face.
Don't you touch my camera.
Yeah.
Don't you touch my camera. I want him arrested.
Oh, there, that's the way we're supposed to behave. Yeah, man, fuck you and fuck your client too. Watch this. I'll make this simple. Mark Rattan, asshole number 1, attacked my cameras and me in contravention of rule and law of a case that was being held in a public hearing. You see it right there. I filed a complaint with the Office of Lawyer Regulation on asshole number 1. Terry E. Johnson, his attorney, or allegedly his attorney, asshole number 2, purported to be the lawyer for asshole number 1. But because he's a punk ass who does not really stand behind his client, he has failed to actually sign any of the responsive pleadings in complete derogation of Wisconsin law designed to maintain the integrity of the system. Wisconsin law clearly requires, i.e. shall, that the attorney of record actually sign the pleadings. What a concept. Even a rubber stamp signature is invalid, as the law has proved. Now, asshole number 2 sits on a panel with the OLR, purportedly a panel designed to reform and to improve the integrity of the process. The OLR has intentionally ignored my concerns on this matter on at least 2 distinct recent occasions, with Keith Sellen, I believe he's the director, asshole number 3, being the most recent violator, as you can see right here in the letter he sent me. Asshole number 2, by the way, was chosen only for his power and influence over the OLR. That much is obvious because he hasn't filed anything in the goddamn case. Now, all of these assholes are in one big circle jerk, big dog and pony show, and I will expose all of it. Now, let's get to the law. The purpose of requiring a handwritten signature on the pleadings is not only to clarify who is acceptable for an invalid argument or claim, but to guarantee that an attorney who is familiar with the procedural and substantive laws of the state on the matter read the claims and made an assessment of the validity, Schaefer versus Riegelman, okay? And you see the basic requirements there. It must be handwritten, signature of the attorney of record, and be in that attorney's name. Now, because no attorney of record signed the pleadings in accordance with 802.051A, the pleadings were defective, and that was clear also in Novak and in Schaefer, okay, both cases, all right? So there you have it right there. And, you know, folks, we live in a nation of laws. And to the extent that the respondent and his purported attorney believe it worthwhile to reach into extrinsic matters of a failed indictment of me on a prior occasion, and a bar suspension that was the result of racism, ignorance, and reactionary politics, according to Professor Lou Jacobs, who was my mentor and a member of the disciplinary panel, we now turn the focus of this case right back to where it belongs. 1. The fact that Respondent Rattan disrupted a peaceful public legal proceeding by alighting from his chair, traversing an entire room, and attacking a complaining party and his camera in direct contravention of the standing law and rule of the case. And 2. The fact that the absence of a valid attorney's signature on a filing renders such filing as defective and properly stricken from the record. Now, y'all have screwed with me long enough, so I'm going to stick it to you like this. Again, in honor of Professor Jacobs' spiritual successor, Christopher Fairman, fuck you. And I mean that from the bottom of my heart. Now you get your ass in there and do your fucking job. Not the job that the establishment has dictated to you to run my case right out of court, but the job that requires you to seek justice to a situation involving a per se, clearly evidenced ethical violation. Your willful ignorance of the import of Statute 802.05 illustrates that any vulgarity in this case was actually initiated by and through the OLR, Respondent and Respondent's Putative Counsel. That's what's vulgar in this case. So all y'all motherfuckers can kiss my black ass.